Today our topic is strict liability. First of all, you will have to, for the examination point of view, you will write down what is liability. That bond that exists, that bond of necessity that exists between the wrongdoer and remedy of the wrong. Then I have told you what Samad, the great jurist, told about it. Then I told you about Marby. What are the liabilities, kinds of liabilities? Criminal liability, civil liability, vicarious liability, remedial liability, and then our topic, strict liability. Strict liability is the exception of that rule, especially in the criminal law, that whenever you will set somebody, you held that person responsible, liable for some criminal act, you have to prove the mens rea. But that very doctrine of strict liability, that doctrine is an exception. Here you will not have to prove a very detailed evidence that that person is liable, that person is held. Just you have to set that he is liable strictly. Why? Due to his capacity, due to his authority, due to his influence. In civil cases, although there is very generally we see there is no role of mens rea, of guilty mind, evil mind, there is no role. In some cases or in shades of some cases, there are, you have to prove that that person had the mens rea in that particular act. Otherwise, strict liability in criminal cases, generally in criminal cases, somebody is punished for his mens rea, his guilty mind, his direct influence, his direct role. But strict liability is an exception. In criminal case, he will be held responsible for his act due to, for example, in public nuisance, if any employee does any act which is a nuisance, which creates nuisance, then that employee is held responsible under the doctrine of strict liability. Likewise, criminal libels. If somebody, some reporter, some editor publishes or in any way gives a news which is totally wrong, libel, then that owner of that group, media group, that publishing newspaper proprietor is held responsible, directly responsible under the doctrine of strict liability.